Okay, hi everyone. I'm back to do a civil procedure video. This is my video number 4 for pleadings. This one's going to be on pleadings, part of the pretrial procedures. We're going to talk about pleadings, Rule 11, pre-answer motions, and amended pleadings. Amended pleadings for California DOE and for federal. Purpose of pleadings. Pleadings are documents that set forth the claims and defenses to a case. The purpose of them is to communicate with the opposing party and the court. Federal court has notice pleadings, which are plausible, not exactly using element of fact. Element of fact is going to provide the opposing party with reasonable notice of the nature and scope of the claims being asserted. Now California is more strict on it. They have fact pleading. The word fact means that they want you to have put each, like for example, negligence, duty, breach, causation, damages. They want you to put duty and what's that fact for that, breach, what's that fact for that. They want to make sure that every element is met, okay? It's more specific than federal notice pleading. They plead the ultimate facts to support each element of the cause of action. So fact pleading for California, more strict. Notice pleading, more plausible, not as strict. Pleading requirements, Rule 11. You'll see a lot of these. Rule 11 is a lot on essays and also on MBEs. Pleadings all over MBEs, tons of them. Requires all attorneys to sign all pleadings, written motions, and papers. Okay, if they don't, they will be sanctioned. We'll talk about that. The paper must be proper. They must know what they're signing. The legal intentions are warranted by law, and the factual contentions have evidentiary support. You don't want to have attorneys sign a pleading that does not have evidentiary support. It needs to be supported, okay? Or why did he sign that? And then that comes into sanctions. If violated, if any of these are violated, may be imposed subject to a 21-day safe harbor rule. If a motion for sanctions is served, the served party has 21 days to withdraw or correct the pleadings. So give them a chance to correct them. 21 days. You got to love all of these. I'll be honest with you, all of these numbers in civil procedure are just awesome, right? Rule 11 does not apply to discovery documents. Now, discovery is a whole different section in civil pro. I'll do a video on that. So it does not apply to discovery documents. So attorneys don't have to sign them, and all this does not apply. They won't be sanctioned for that. It's a little bit different. Okay, so it has 21 days to withdraw or correct the pleading. That's important to remember. That's Rule 11. Now, what types of pleadings are there? There's the complaint, the response to Rule 12, Federal Rule 12b defenses, which are important. California has a demurrer. California has a motion to quash service of summons. Now, federal complaint rule used by a plaintiff to raise issues. They're going to use a federal complaint to raise any issues. The federal complaint must include the ID of the parties, proper SMJ, statement of the claim. Remember, it's plausible. It's not to the fact. But fraud, mistake, of course, there's always an exception. Fraud, mistake, and special damages, not just plausible, but specificity, which means they want element fact for this one. Everything else is just plausible. Now, there must be a demand for judgment in the federal complaint and signature of the plaintiff or his attorney. All of this has to be found in the federal complaint. I don't see much on it, but I do sometimes see plausible. Is it plausible? Okay. Complaint for California now. Complaint for California, ID of the parties, an exception for the DOE. We'll talk about DOE at the end here. Statement of the claim, statement of facts, and they want a fact pleading, remember. Fact pleading, fact to element, a demand for judgment, and signature of the plaintiff or his attorney. Response, this is the response to the complaint. This is the Rule 12 motion. Requires a D to respond by either a motion or by answer. This is important. I see this all the time. They want the defendant to respond by a motion or by an answer within 21 days after their service of process. Okay? 21 days after their service of process, or within 60 days if they waive the service. 21 days if they don't waive it, 60 days if they do waive it. California only allows 30 days to respond. Of course, California has to be different on all of this stuff. So California allows 30 days to respond, 21 days for federal. Pre-answer motion, motion for a more definite statement, used where the complaint is too vague. Okay, you see a lot of these on MBEs. The complaint is too vague, so California has a special demurrer for that, and grounds pleading is uncertain. Rule 12, motion continued, motion to strike. So that was the first one here. The motion for a more definite statement saying that the complaint is too vague. And now there's a motion to strike. We're going to use Rule 12, motion to strike, aimed at pleadings containing immaterial or redundant issues. For example, demand for a jury trial when there is no right to one. Remember, jury trial, right to a jury trial is 7th Amendment. You have to read about that. 7th Amendment. If there's no right to one and that's in there, in the pleading, the opposing attorney can do a motion to strike, okay? So it's redundant or immaterial issues for motion to strike. California has an anti-slap, of course, motion to strike, used if to chill the valid exercise of free speech and petition. Defendant makes an anti-slap motion to strike. This shifts the burden onto the plaintiff. That's basically what he does. He's just shifting the burden onto the plaintiff to show a probability of winning on the merits. Okay, I haven't seen that, but you never know. Rule 12B, defenses. So those were the 12B issues they can bring up. More definite statement, motion to strike. Now the defenses to that can be raised by a pre-answer motion or in the answer. Lack of SMJ. Remember, these are very important. I see this all the time. Lack of SMJ can be raised anytime, all the way up into appeal. Anytime. Lack of PJ must be raised in the first response or it's waived. You cannot raise it later. Improper venue must be raised in the first response or it's waived. Insufficient process, first response or waived. Insufficient service of process, first response or waived. Failure to state a claim, there's really no issue, no claim there. Raised anytime until trial is concluded, anytime. Failure to join an indispensable party, which I'll talk about later, anytime until the trial is concluded. These have to be memorized because you do get a lot of MBEs on these, okay? Most importantly, SMJ can be raised anytime up into appeal. PJ, no. It's deemed waived if you don't raise it in the first response. Now the California demurrer, general or special, typically used to respond to the complaint. A general demurrer, pleadings fail to state facts sufficient to constitute a cause of action. Remember, they want fact pleadings there. Court lacks SMJ. So this is when you would do a general demurrer, when any of these two take place, A or B. Now, a special demurrer is only allowed in cases classified as unlimited. Remember, unlimited cases are 25, they have to be 25,000 or more. Those are the unlimited. These issues can also be raised in the answer. A special demurrer on certain pleadings, lack of legal capacity to sue, existence of another case, defect or misjoinder of parties, contract is oral, failure to require certificate. Okay, so this is California. California's motion to quash, service of summons done by means of special appearance, must be made separately from the answer, must be made either before or concurrently with the filing of the demurrer. The following defenses are deemed waived: lack of PJ, insufficient process, and insufficient service of process. The answer, now this is the answer. An answer is the defendant response to the complaint. So the defendant's responding to the complaint, that's the answer. Defendant must respond, here's our dates, within 21 days after service of process, or if he's waived service of process, he has 60 days to respond, and we talked about that earlier. California gives them 30 days to respond. Defendant must respond to allegations. Defendant must also assert any affirmative defenses in his response. And California wants fact pleading, very specific fact pleading. Federal doesn't. They want plausible, except if it's fraud and those other ones. Amended pleadings. Can they amend a pleading? Yes. Right to amend. Federal court, P has a right to amend once. This is important because I see this on MBs. Once within 21 days of service. Federal. Defendant has a right to amend once within 21 days of serving his answer. After he serves his answer, he has 21 days to amend it once. California, plaintiff has the right to amend once before the answer or demur to the complaint is filed, or after the demur is filed, but before the hearing on the demur. Okay, that's California. Federal relation back doctrine amends the pleading back to the date of the original filing for purposes of the statute of limitations. Seen a lot of MBs on these. If they concern the same conduct, this is the tricky part, transaction or occurrence as the original pleading. They can amend back. They will relation relate back to the original filing, the pleading for purposes of statute of limitations. Amended defendants relate back if same conduct, the same TNO as the original complaint, the new party knew of the action and is not prejudiced in maintaining a defense, also knew that, but for the mistake, they would have been named in the complaint. So this is when you want to add a party. I forgot to name a party, okay? Relation back doctrine. I've seen this in MBEs and Lawson essays. Now the relation back DOE amendments, California permits suing a DOE, which you don't know the name, if complaint was timely filed, includes allegations against the DOE. P truly does not know the name of the DOE. P must substitute a name D for a DOE defendant within 3 years of the filing. It will relate back to the original filing date of the complaint. Okay, that's the California DOE. Okay, so that's pretty much it. Now the pleadings, the purpose of the pleadings, remember the most important things here, federal court is notice pleadings, California is fact pleadings, plausible and really, really strict. Pleading requirements, Rule 11, the attorneys must sign all pleadings, writings, and know what's in them, or they're sanctioned. They have 21 days to fix it. Types of pleadings is the complaint first, and then the response by the defendant, and then Federal Rule 12B defenses, California demurrer, California motion to quash. Federal complaint has to have all of these in it. Complaint of California needs all of these with the exception of DOE. Response Rule 12, pre-answer motion. Motion for a more definite statement. Motion to strike and the anti-slap from California. Remember, these are the defenses. Lack of SMJ can be raised any time. Lack of PJ, no. It's deemed waived if it's not raised in the first response. California demurrer. California motion to quash. Answer. In the answer, remember they have 21 days to respond. After statute service of process, if they waive the service of process, they have 60 days to respond for federal, and California just gives them 30. There must be a fact pleading here for California. Amended pleadings, they can amend. They have the plaintiff has one time to amend within 21 days of service. Defendant has one time to amend with 21 days of serving his answer. Relation back doctrine relates back if it contains the same TNO and the same conduct and in the original pleading, okay? Remember, DOE amendments, they don't need the name, but they have to truly believe that they don't have the name and includes allegations against them. And California permits suing a DOE, not federal. Civil procedure approach, preliminary issues, pretrial procedures, disposition of a case without trial, post-trial issues, appeal, use of final judgment. Now, preliminary issues, basically these are my huge, huge issues, and there's obviously sub-issues here. So preliminary issues, you have to memorize that there's PJ, SMJ, supplemental jurisdiction, removal and remand, venue, notice, and choice of law. When we get to pretrial, we're here right now. We're doing pleadings. Next, I'm going to do joinder of parties, joinder of claims, class action, or discovery. So you have to know the sub-issues for all of these, okay? So preliminary issues, I've done PJ, SMJ, supplemental, removal and remand. I've done venue, notice, and choice of law. Those are on videos 1, 2, and 3. This is video 4 for pleadings. And next, I'm going to do joiners of parties and joiners of claims for video 5. And I'll see you guys on my next video.